Welcome, everybody. We're glad that so many of you care enough to attend a meeting in the summer. It is summer now, and work on these issues that never cease to pop up that we have to keep taking care of. Thank you for your courage and endurance. We always open our meeting with a pledge to the flag. There we go. And then we'll ask you to mute yourselves while we have announcements and speakers. And the first announcement is that our next meeting will be in 4 weeks from tonight on Thursday, July 22nd, and we will still be on Zoom for that meeting. And our speaker is still to be announced. And the next announcement is, I know some of you are new and haven't been with us before. We do still have memberships available. It's a steal at $20 for the calendar year. And you can go to our website and sign up and either use PayPal or just click on the donate button on there. And the website is demsofcasagrande.org. And I'll put that in the chat when I stop talking. And I think Debbie Broom, if you're there, you have the next announcement.
We have a project in the works. It's a highway maintenance project. You know, you've seen these things where there's a sign and people wear vests, and we kind of advertise our club. And Noel Reck is in charge of that, and he's requesting volunteers for the Adopt a Highway project. And his email, I will put it in the chat. We would like to, we're not going to do it now because it's just too hot out there, but weather permitting, we want to start that. And the section of highway that we got is from Selma Highway off of Jimmy Kerr Boulevard, which is Highway 84 to most of you. And it's from Selma Highway east, almost a mile. So, you know, we're obligated to do something, cleaning up the highway twice a year. And I think it would be a good advertising for our club, and that Democrats are alive and well in the area. So I think that we should get, you know, 10 or 12 people to sign up for that. He has to know how many, because he needs to order vests and you know, for the people who are going to go, and then he's going to organize everything. So I will put his email in the chat, and if you don't get it, we can, you know, you can email me or anybody from the club, and we'll get hold of them, and we'll take it from there. But that's going to be a fun project for us to do sometime, probably starting in the fall.
Okay, thank you, Debbie. Are there any other announcements? Okay. Well, tonight we're very pleased to have Brian Radford with us. He is a candidate running for the AZ House in LD11, trying to get rid of who we couldn't sign enough petitions to unseat. So we have to unseat him at the ballot box in 2022. And you are our first candidate of this next campaign season, and we'll hope to have you back often. We invite candidate updates at all our meetings, that whenever candidates wish to come tell us what they're up to. So you have about 5 minutes to tell us something about yourself.
Okay, well, I'm glad to be here. Like she said, I'm Brian Radford. I'm here in LD11. I'm down on the lower end. I'm over in Catalina, which is near Saddlebrook. So our district is long, and I don't know what it's going to look like in the future with redistricting, but I'm trying to get a head start to get started because of all the bad, toxic stuff that we're dealing with. It's become unbearable, really. And Fensham, he can't run again in our district, but he's going elsewhere. I don't know how that's going to work for him. I think he's pretty much done here, I hope, in Arizona. But we still are left with Brett Roberts. There's 2 representatives in the district, and then we have Vince Leach. So all 3 are bad. I'm getting on board early because there's so many issues that we have to tackle this round. just to give you a little bit of my background, I retired out of the Department of Corrections. I worked in corrections for many, many, many years. So I know law enforcement, I know prison reform, I know the things that we should be doing. I'm questioning why they're asking for another 16 million when the population is shrinking. There's actually talk of closing large portions of Florence because of the aging of the buildings and the less population that we have. There's really not a need, and I question why they're asking for so much money. Other than that, I worked special education in the school systems here locally. I have 2 kids that are autistic. I do foster care. I have 4 boys. 3 of them are teenagers and one's a 10-year-old. So I have 10, 13, 14, and 15. So I will be going totally gray here soon. I've got to have 3 or 4 in high school. So I'm befuddled about education in this state. I don't know why we have to stay at the bottom. And that's another pet peeve of mine. They railroaded us with the budget that they just put the budget through today. And to just take billions of dollars in future taxes away, that's reckless. I remember back when we had to sell buildings and lease them back because we didn't have enough money. Everybody knows when Brewer was in there, we had to, and I was like, what are they doing? They're selling the State House. How can they sell the State House? And it was to raise funds because it was that bad. So to just give away the taxes like that, I'm not saying that it should be increased, but we need to be smart with what we do have and invest it wisely. I think education has been lagging for a long time. I'm big on supporting Red for Ed and Invest in Ed and all the education for public schools. I'm disappointed that they're expanding the voucher program. They're taking our public tax money to private schools. I don't agree with that. I know people want to have a free choice of open enrollment, but you can do that in public schools also. So that's a big part. The foster care, fostering the kids. I've been doing this for several years. And again, when I see thousands of kids just lingering in the system and nobody's really, you talk about folks that are right to life and all this stuff. And it's like, okay, so you have all these foster kids in the system. What are we doing for them? How are we supporting them to be successful when they age out of the system? You end up with a bunch of homeless teenagers that don't have no structure, don't have no parental guidance. So that's another thing, DCS and the future of that agency and the funding and the things that we're doing. So there's a lot of things that, and we all know this, as fellow Democrats, we're out to help other people. We want to be helpful, we're the helpers. And just to see the environment that we're in now and all the stuff, the authoritarian type things that they're putting across is just wrong. So we need to be able to make a strong effort to say, there's other ways of doing this in a more humanely appropriate way and to get our message across. So I'm starting early. I hope to represent our district. I'm just a regular person. I'm not a politician by no means. And just to get regular working people that understand kids, education, being able to put food on the table, jobs, small businesses, all that stuff. And it's all on my website. I have a site, it's radfordforaz.com, just like it sounds, radfordforaz.com. And you can check everything out about me, about the issues and all that. And we'll be growing as time goes on, and I'll be coming back in, and hopefully when we have in-person meetings, I will be glad to come up and be in an in-person meeting with you guys. And along the way, I'll be looking for volunteers and for helpers to help push our message, because I'm one of our own. I live right here in District 11. So I'm trying to represent us and get our voice in there into that State House.
Great. Thank you so much, Brian. And would you put your website in the chat? Because I tried to find it and I was typing it wrong somehow. So.
Oh, okay.
If you would drop that in there, then people can pick that up out of there. Thank
Okay,
you.
certainly.
I just did that, Betty.
Oh, thank you. Debbie did that for you.
Okay.
You're good. This is why we
Okay.
make you co-host. So, okay. Next, we have a brief update on the We the People Amendment, which is a joint resolution. What? Somebody say something? In the House of Representatives to amend the Constitution to abolish the doctrine of corporate personhood from Citizens United and also establish that money is not the same as speech and therefore is not protected. Debbie Burdett is the member who brought this to our attention, and she arranged for Molly Harmon to be with us to speak tonight. And Molly's from the Move to Amend organization. So Molly's going to give us about a 10-minute update, and take it away, Molly. Oh, it says Millie. Oh, I'm so sorry. That typo has multiplied. So we'll get it right from here on out.
No problem at all. Well, thank you so much for having me, especially to Debbie for setting this up so short notice. I'm going to try to share my screen here. And let's see what we get. Are you all able to?
Yes.
Okay, hopefully just see the slide. All right. So again, my name is Millie Harmon. I'm the outreach coordinator for National Move to Amend. I happen to also live in Cottonwood, Arizona. And so Move to Amend, let's jump into it. So Move to Amend is a nonpartisan coalition of hundreds of organizations and hundreds of thousands of individuals committed to social and economic justice, ending corporate rule and building a vibrant democracy genuinely accountable to people and not corporate interests. Our campaign is centered around the passage of the We the People Amendment, a 28th Amendment to the US Constitution, currently introduced as House Joint Resolution 48, that would make clear that artificial entities do not have constitutional rights and that money is not a form of political speech to be used to influence our elections. And I sort of want to take a moment to underline here that this is the only solution on the table that addresses Citizens United by going at the precedent, which is corporate constitutional rights. And that spans way further back than that ruling. So actually corporate entities are not mentioned in the US Constitution at all. There's no legal foundation in it at all. And as we can recall from grade school, right, the revolution was in part a revolution against crown corporate entities. So at our founding, we, there were many actually papers written by founding fathers predicting the possibility of corporate rule if we allow corporations to amass too much power. So at the beginning, corporations were created and defined by we the people and public officials by charters, which were both granted and revoked. So charters were given as a public service. Most of the time it had a limited amount of time, and it was very common for charters to be revoked if they were no longer serving the public good. And of course, political money had no rights. So corporate constitutional rights were not originally intended. They were not inevitable. It's also not irreversible. But again, to underline that it was not created by any law or regulation or passed by any elected official or citizens initiative. This was a very conscious, planned effort by corporate attorneys and activist judges spanning all the way back to 1886. So here is where it began, the corporate hijacking of the 14th Amendment. The fiction that corporations have constitutional rights arose out of a court reporter's false, unofficial comment that the Supreme Court had given corporations the same 14th Amendment rights as natural persons in a case called Santa Clara County versus Southern Pacific Railroad, which happened in 1886. And despite footnotes having no legal validity, this set the precedence for corporations being protected under the 14th Amendment. And of course, come to find out, the court clerk that inserted this footnote had connections to the railroad company. So I want to really examine here all of the constitutional rights that corporations have usurped. The Fourth Amendment, search and seizure rights. So any efforts to inspect corporate property to ensure compliance of health, safety, and welfare standards for workers can be overruled because corporations can claim search and seizure rights. They also have claimed Fifth Amendment takings rights, which is an effort to protect private property from corporate extraction. Which I want to give a recent case that just came out this week in a 6-3 ruling. The Supreme Court ruled this week and it overturned a California regulation that allowed union organizers to enter workplaces to recruit agricultural workers on the grounds that it violates the 14th and 5th Amendments rights of the corporation. And this overturned a regulation that had been in place since the 70s after the United Farm Workers Union successfully argued that the only practical way to give farm workers a realistic chance to consider union membership was obviously to approach them in the workplace. So this was just this week overturned. We're all very familiar with this. Corporations have won First Amendment free speech rights. And so any efforts to limit money in elections will be overruled. They have also claimed First Amendment right not to speak. Another recent case with this was Roundup, and that went all the way to the Supreme Court, and they claimed the First Amendment right not to speak, therefore allowing them not to label their product with known cancer-causing ingredients. This precedent has also allowed corporations to sue and not label genetically modified organisms. Another First Amendment protection that they have claimed is religious right, which we saw with Hobby Lobby, in which a corporation sued and got religious rights, and therefore the ability to not provide comprehensive reproductive health for their employees. Another one that we've seen is corporations winning rights under the contracts clause. So as I said earlier, that previously charters were revoked when they no longer served the public good. We have lost that ability now with them being able to claim rights under the contracts clause. So here's a case we're all very familiar with, Citizens United. This was not the first case where corporations claimed that money was a form of free speech, but it did eliminate all the prior limitations on campaign contributions that had been set by the FEC. It was a ban on political spending by corporations and unions was deemed unconstitutional because it violated the First Amendment protection of free speech. And we have seen the devastating effects of this year after year, 2020 being the highest, most spent on an election than ever before. So again, bottom line, this is so much bigger than just money in politics. Corporations have hijacked our Constitution, and working with the judiciary are able to use it against us in court. Solutions like the Green New Deal, Medicare for All, HR 1, and important democracy reforms that address voting rights, gerrymandering, etc., environmental policies, consumer protections, worker protections, and rights, all require addressing corporate constitutional rights first, because until we do, any law that we pass is able to be overturned in court by corporations using their constitutional rights along with their mass amounts of money. So this is a constitutional democracy crisis, not simply a money and politics issue. We've had a lot of success. I think I'm using up a bit of more time, so I don't want to go too much over.
Start wrapping up.
So you can look up on our website. Last year we had, last Congress, we had 75 co-sponsors in the House. We're currently at 63. These are some successes that we've had in Arizona. Tucson and Flag have both passed city council resolutions in support of this amendment. We do have a co-sponsor, Representative Grijalva, and this is just a short list of the many endorsing organizations in Arizona. We have 3 targets: Representative O'Halloran, Representative Kirkpatrick, who has taken our pledge, but she hasn't come through on her promise to co-sponsor, as well as Representative Gallego. So if you know anybody with those reps, please spread the word. And now here, how you can help. The first initial thing for all of you, please take a moment to sign our petition at movetoamend.org/motion. I will put it in the chat after this. And when you sign the petition, please put your full address. And the reason that I ask this is because we use the petition as a tool for lobbying. And so we can't determine what congressional district you are in necessarily unless you put the full address, because some zip codes straddle more than one district. We do not share our lists. We will not mail you anything. The other thing that you can do is to call Congressman O'Halloran weekly. Myself and a group of constituents met with them a couple months ago, met with his legislative director, and we haven't gotten an answer yes or no yet. So we take that hopefully, and we need more constituents to help us continue to pressure them. If you sign up, if you sign the petition, you will receive weekly reminders from me to call with a script and numbers provided. And lastly, please consider passing an organizational endorsement. As we are a coalition, this is another really great tool that we can use to approach our representatives and say, you know, this is something that your constituents are demanding.
Yeah. Thank you so much, Millie. And I do want to let you know, Casa Grande, the Democrats of Casa Grande are poised to make that endorsement. We're just waiting to give members an opportunity for feedback. So if people have opinions about that, please email Democrats of Casa Grande and let us know one way or the other.
Perfect. And feel free, I'll put my information in the chat as well. If any questions arise, if you have other contacts around the state you'd like to get involved, please do contact me. Thank you so much for your time. I very much appreciate it.
Millie, can you make the the presentation available to the club mail without your PowerPoint?
Absolutely, and I'll actually include a couple really great recommended short readings that kind of give you the gist of what I've just said.
Okay.
Thank you.
Stop my share. Now, any questions too?
No other questions? Okay. Debbie Broom will then introduce, yes, thank you very much, Millie. That was very informative.
Thank you.
So Debbie, it's to you for our featured speaker.
Okay, our featured speaker tonight is Dianne Post from the Secular Coalition. Dianne has been an attorney for over 40 years. She represented battered women for 18 years and then began work in international human rights law. She is the legal director for the Secular Coalition for Arizona and the coordinator for the ERA Task Force Arizona. And so I'm happy to introduce Dianne Post. Thank you, Dianne.
Hello, I'm going to share my screen, and while we're doing that, I will tell you that I'm okay with questions during the presentation. Has everybody got the screen? Yes? Okay, I'm okay with questions during the presentation, and if we're gonna if I'm gonna answer it anyway, then I'll just say, okay, I'll answer that later. Or Betty, do you think it's better to wait till the end or put them in the chat?
Whatever works best for you. We're fine.
First, I want to say Millie's absolutely right. And notice something, that corporations got 14th Amendment rights in 1877. Women, human people, did not get 14th Amendment rights until 1973. Yeah. All right. So, Equal Rights Amendment. Let's not delay. A lot of us know this history. In 1972, well, it was, whoops, I think I missed something there. There, I did. All right, Alice Paul, she was a lawyer, and she first, after the 18th Amendment passed, women got the right to vote. She knew, and they knew, voting wasn't going to be enough. We also had to have legal equality, or we're not going to be able to use our voice in the way that it should be used. And not only should we be able to vote, we should be able to represent, right? Have equal representation. So the original statement is what she wrote there in 1923, but you notice it changed. And the reason it changed was to follow the language in the 18th Amendment, because I'm sorry, not the 18th, the 19th Amendment, because it had already been passed. They wanted to mimic that language, thinking that would make it more palatable and therefore more likely to pass. And also notice section 3 down here. The amendment takes effect 2 years after it's passed. And that becomes a legal issue much later, because we say it was passed January 28th, 2020. So that 2-year window is coming up, and there will be lawsuits. There will be. So it was introduced in 1923 into the Congress, but you notice 72 before it passed. 49 years just to get it out of Congress. Now, I gave a talk down in Green Valley, Arizona, and a woman who was attended there said she actually worked for Martha Griffiths at the time when Martha moved from Michigan to Washington to her office. Well, when you go into your office at a new job, what's the first thing you do? You clean it out, right? And you bring in your stuff. So she's going through the drawers and the filing cabinets and everything, and she pulls out a folder. And this folder has, remember when there were manila colored folders and they had the little tab on the side, and the name of what was in the folder was on the tab? Well, it said broads. Broads? What could that possibly mean? So she opens up the folder, and it was the Equal Rights Amendment.
It was the what?
It was the Equal Rights Amendment. Her predecessor had put the Equal Rights Amendment in a folder called Broads and left it in the filing cabinet for her. Well, that ticked her off, shall we say. So she made it her determination to get this thing passed. And she didn't the first year, but she did the second year. Now, notice that Arizona senators and Republicans or representatives have been standing up for the rights of Arizona men. Not a one of them voted for it. None of them voted for it back then or since. And the timeline, this timeline was put in the preface. This makes a major difference in the law and in the legal arguments that we're making now today, how many years later after 72? Because any lawyer will tell you, I don't think anybody here is a lawyer besides me, or are there any lawyers? No? Any lawyer will tell you that what is in the preface is not law. It's what is in the context that's the law, in the subject that's the law, not in the preface. All right, after it was ratified in 73, after Congress passed it out in 73, because Article 5 of the Constitution says 2 things have to happen. First, Congress has to pass it by a 2/3 margin. Well, that's what happened in 72. Then 3/4 of the states have to pass it. That's what happened on January 28th, 2020. The 3/4 state, the 38th state, Virginia, passed it. It's done. It's passed. According to Article 5 of the Constitution, it's done. So this is our legal position. It was done January 28th, 2020. So January 29, 2022, it's in effect, and we can start suing on it, and we will. All right, so when it was passed in 72 out of Congress, Hawaii, of course, the time difference and all, it was ratified in 30 minutes. They were still up. So it was ratified in 30 minutes, and then it was a very quick ratification because a lot of positive things were happening for women's rights in the 70s. Well, then along came Charles Koch and Phyllis Schlafly. And I just recently learned a year or so ago that it was the Koch brothers that funded Phyllis Schlafly. Way back then, they were the ones who put up the funding for her. And she was kind of more interesting really than you would think, because she was really an expert in international law of war. And she wrote a couple of books on it, but the men wouldn't pay any attention to her because she was a woman. What the hell does she know about war, for God's sakes? So she could see that she was getting nowhere. She was a lawyer too, you know. She was getting nowhere with trying to make a career out of what she wanted to talk about, which was the law of war. So she was going nowhere. So she said, well, I know how I can get famous. Well, here I am. Let's turn against women. So this is where the men wanted her, of course, because you want to put a woman out. So between 79, there were no new ratifications. That then is when the extension occurred for 3 years, from 7 years to the 10 years. So it was going to 82. And that extension was passed by a majority. Now I notice I got down here was passed by 2/3. Sorry, passed by a majority, not passed by 2/3. And that's one of the legal arguments that the opponents are using today. They're saying, well, that extension wasn't passed, isn't legal anyway, because it wasn't passed by the required 2/3. Well, the extension does not need 2/3. That's the amendment that needs 2/3, but it doesn't matter anyway, because that extension is long past, right? And that's a legal argument, and I'll get to that towards the end later on. All right. So,
Excuse me, Diane. Something seems to be happening with your mic and paper rustling, so we're getting a lot of static.
okay.
Yeah, I don't know if the paper's sitting on the mic or quite what, but
Maybe it was sitting on the mic. I think it was.
okay.
All right.
Great,
So
now I can hear you.
Okay. These are the Arizona attempts to pass the ERA. It was first introduced by who? Sandra Day O'Connor.
Oh.
She was in the legislature at the time. She was, still is, as far as I know, a Republican. She introduced it and she got nowhere. After it failed in 72, she was gone after that out of the legislature, and Sister Claire Dunn, who was a sitting Catholic sister, introduced it twice, and it didn't get passed. Now, of course, there's the opponents use the argument of, well, it's about abortion. It'll legalize abortion, you know, everything else. Well, Sister Claire Dunn said at the time, if this was about abortion, would a sitting Catholic sister be introducing it? No, she wouldn't, and it isn't. So it was introduced off and on again over the 80s and the 90s. And then every year since the 2000s, it's been introduced every single year in the Senate and the House for 21 years. It's never been assigned to a committee, never been assigned to an agenda, never been heard. 21 years, never been heard. Well, ever since 72. Well, no, it was voted down in 72. It wasn't heard in 75 or 79. So you can see that we've done, the ERA task force became very active in 2017 is when we started in 2015, but we got more active in 2017. And you can see that things happen, and we tried to do floor maneuvers. We tried to do other kinds of discharge petitions and different things over the years to try to get it on the floor. And we so far have not been successful at that at all. So then there were two possibilities nationally of how to get this done. Should we start over, or should we go with the three-state strategy? I was a very strong proponent of the three-state strategy, and that is because if we start over, we won't get it. You know how many states are ruled by Republicans today? Well, first, we wouldn't get it out of Congress. How would we get it out of the Senate? If we can't get SJ1 out of the Senate, SJ Res 1 out of the Senate, which I'll tell you about, how are we going to get this out of the Senate? So if we started over, we couldn't do it. I mean, maybe someday, but not today. So anyway, the three-state strategy was sort of where everybody went at that time. And that was, we only need 3 more states, so let's get them. So we got them. So Nevada in 2017, after they flipped from Republican to Democrat, Illinois in 2018, which is where it had stopped way back in 79, and Virginia in 2020. And by the way, just a side note, I moved here in 1980, here in Arizona in 1980. And in 6 months, I was the state chair of the ERA task force. In 1980, I started working with them right away because, you know, there was such a thing. And then the woman who was the chair ran off with the money. Yeah, great. So I ended up to be the chair 6 months after moving here. So I have been working on this for a very long time. All right. So I told you we now have the 3-4 states, the 38th state, and the archivist who is required to publish the law in the Federal Register has published that Nevada and Illinois did it. He's refusing to publish that Virginia did it, which is the 38th state. Because why? Because Barr, the Attorney General under Trump, told him not to. So, and we're going to follow up more on that as well. All right. So here's where there's a couple of shocking things. One is that 80% of the people in the United States think the ERA passed. They think it passed back in the 70s. And when you talk to people, and this has happened to me over and over and over again as I went around the whole state and spoke when we were doing that before COVID, 80% of the people thought it had passed. What are you talking about that for? That passed a long time ago. No, it didn't. So most people don't even know that. All right. So a poll was taken in 2019. And one of the questions asked was, did you even know that the ERA was an issue? And most people did not even know. Only 27% of the people of Arizona said they knew that it was even an issue. 27%. So that sort of changed our strategy in that we decided we really had to go out in the rural areas, and because it's easier to get to the, you know, large urban areas than the rural areas, we really had to get out there and do that. And that sort of changed our strategy in that way. Then they broke down who knew what by gender, region, age, and party. And no surprise, women actually didn't know any more about it than men did, which was kind of a surprise. But Democrats did know more about it than Republicans. The best county, where the most people knew about it was Pima County. No surprise. And older people knew about it more than younger people. Because of course the older people were around when it was around before, and it was a big talk of the news and everything. And the younger people, they never even heard about it. They didn't have a clue what it was. So then they broke it down by age, and this is still on, did you even know about it? The most likely to know about it were older males. Isn't that interesting? Why? Because it was a threat to them. Older, I can understand because we were here when it was going around before. But males more than females, I found that interesting. More likely to know about it was Pima County, same dynamic, and older Democrats, same dynamic. The people who knew the least about it were older independents. Now, whether that's because they don't follow things as closely, I don't know. So then after they found out whether you knew anything about it or not, they asked, do you support it? 63% of all the people in Arizona said yes, they support it. And how was that broken down? Women slightly, just slightly more than men supported it. What I thought was quite interesting was Pima had the highest percentage of support, but the other counties, the rural counties all around, had a higher level of support than Maricopa. Yeah, we were surprised about that because you wouldn't think those rural counties would have a higher level of support than Maricopa County, but they did. So that was a bit surprising. Younger people were more supportive than older people. Once they knew about it, they didn't know about it, but once they knew about it, they said, well, yeah, of course we support that. And then Democrats were way ahead on support than anybody else, the Republicans or the independents. Then they broke it down by age. Younger females had the highest level of support. Again, no surprise there. Younger people in Maricopa County had the higher level of support. Younger Dems, 86% of young Dems supported it. And the least support came from old Republicans. 39%. Again, none of that is all that surprising. But we use this stuff to strategize about where we need to do what kind of work. Oops, I skipped one. All right, so then, of course, after the 38th state passed, which was Virginia in December 28th, 2020, along came the lawsuits. Well, you know, that's going to happen. So Alabama is one of the states that has never passed it. And so they and some 5 other states filed a lawsuit in Alabama in federal court before it was even passed, before Virginia even passed it, because it was pretty much known they were going to. So they brought the law before it even passed and to oppose it. Well, that lawsuit was dismissed because they said, it isn't even passed. You don't have any leg to stand on here. There's nothing happening. Get out of my court. So then in Boston, Massachusetts, in January 2020, Equal Means Equal, which is an organization that works for the ERA and other equality for women, jumped the gun also. And they filed it before it was passed, which they should not have done, but they did. So they filed it before it was passed, and they filed a suit in Boston, Massachusetts. Well, the court there said, you don't have any standing. It hasn't passed. And it isn't in effect. Remember that 2 years? It isn't in effect yet. So you don't have any standing. So they tried to skip the appellate court and go straight to the Supreme Court and get not only a ruling on standing. Well, let me explain standing for those of you who might not know. Standing in legal terms means you have the right to bring the suit. You have the right to bring the suit because it's going to impact you. The action that is going on will impact you. And the court can make a decision that will resolve the problem, because they're not going to make advisory ones. And if you don't have any skin in the game, they're not going to make a decision for you. So you have to have the right to bring the suit. And there's a lot of different, ramifications to that. But standing means you got the right to bring the suit. So they said, you don't have standing. You have no right to bring the suit. It hasn't even been passed and it's not in effect. So you can't sue on it anyway. So get out of here. So they went to the Supreme Court trying to get a ruling on that. Supreme Court said, no. Get back down there and go through the process like everybody else. You have to file an appeal first in the circuit court, and whatever happens there, then you come to the Supreme Court. So they were kicked back down, and they had to file their appeal in the appellate court in Massachusetts, which they did. And they had their oral argument on May 5th of this year. And it'll probably be a couple of months. It has to be 60 days. Yeah, so it'll be soon, because May, June, July, it'd be July 5th. So they have to have a decision by July 5th. So we're waiting for that written decision. Then the third lawsuit was filed 2 days after it was, year actually, after it was final, because it was filed January 30th, 2020 by 3 attorneys general, the last 3 states that ratified. So the Attorney General of Nevada, Illinois, and Virginia joined together. The 3 of them filed, those 3 states filed an action in Washington, D.C., saying that the Fiero, who is the archivist, must publish this and that it is in effect. So they were dismissed. The court dismissed the case on March 5th, saying that, there was a timeline. Remember that 7-year timeline that was extended to 10? That brought it to 82. Well, 82 is long past, as we all know. So that's it now. You pass the timeline, you can't do it. Well, that's not true. And so they have appealed that, and they filed their appeal on May 3rd, and they expect that amicus will be due by the end of August, decision by the end of December, et cetera. But whatever happens, it'll still go to the Supreme Court. So they won't make it next year. It'll still be the next year after that before we get a decision. So we knew these lawsuits were happening, and the lawyers were all geared up, and there we are. All right, now, what are the legal arguments? This is one legal argument. Under Trump, he told Barr to submit a memo saying the ERA was no good because of the timeline and because of rescissions. There are 5 states that said, sorry, I passed it, but I take it back, I take it back. I changed from Democrat to Republican, so now I take it back, I take it back. Well, they can't do that, but they said they did. And so those 5 states, if you had 38, you need 38, and you got 38. Well, if you didn't have those 5, you have 33, right? So you didn't make it. So this is what they say. And also that the timeline passed in 82. And I'm going to get to this in a minute. Why neither one of those are good arguments. But Jimmy Carter had put in a memo in favor of the ERA when it first passed back in, 72 or 79, actually, when he was in. So now Trump had Barr issue a new memo from the Department of Justice, from the Attorney General's office, saying it's no good. So that memo was then sent to the archivist and said, do not publish the Virginia ratification. So that's why he hasn't published it, because of this memo from the prior administration. So you'll see on the screen, I've got an action. We want you to write a letter to the Attorney General Merrick Garland, withdraw that Department of Justice memo. Withdraw it. Either submit the old one that Jimmy Carter did, don't submit any, or submit a new one, but withdraw that memo. What else they did under the previous administration was the US jumped in on the wrong side of both of those lawsuits, the one in Massachusetts and the one in Washington, D.C. So the federal government is now in both of those lawsuits saying no to the ERA. Biden needs to get out of those lawsuits. So tell Merrick Garland, there's his address, you can email him, whatever you'd like to do, get out of those lawsuits or come in on the right side and withdraw that memo. Either have nothing or put in a good one, okay? The two legal arguments that have been used against this are the timeline and the rescission. Now, the timeline argument, why we say we win this one, is because under the Constitution, Article 5, how to amend the Constitution is completely up to Congress. It is not up to the judges. It is not up to the president. The president has no power in it at all. And when the ERA, when the amendments are passed in the states, governors don't sign them. It has nothing to do with the executive branch. It is only the legislative branch that can do it. So it is completely up to Congress. They can do or not do whatever they do. Also, in Article 5, there's nothing about a timeline. It says 2/3 Congress, 3/4 states. That's it. In the past, there were no timelines until the 18th Amendment, the prohibition. I think that was the first timeline. And then the 7 years was put on there because they didn't think they could pass it. They didn't want it passed, actually. And so they thought, well, we'll put a timeline on it. It'll never get through. Well, bam, it passed in about 18 months. Of course, then they had to withdraw it with the 21st Amendment a few years later, but there you are. So it's not required and it's not necessary. And many amendments have been passed without it. And it was in the preface. It was not in the body of the law. Remember that business? It was in the preface. It is not what the states passed. The states did not pass ratifications that said 7 years. They passed ratifications that said ERA, period. What I showed you at the very beginning, that's what they passed, not 7 years. So there's all kinds of legal arguments about it. And there have been lawsuits. There have been lawsuits about the 14th, the 14th and 15th Amendments and the 18th Amendment, 19th Amendment. So surprise, surprise, people brought lawsuits against ending slavery and against women's suffrage. What a surprise, right? So all of those lawsuits lost. And they argued, well, it wasn't the timeline. Well, it wasn't this fast. Well, we rescinded. Well, blah, blah, blah. They lost. Every one of them has lost. And these people are going to lose too. The other argument about the timeline is, who knows what the 27th Amendment is? Don't raise your own pay amendment. It was an amendment that says, when you're seated in the House or Senate, you can raise the pay for that position, but you don't get the benefit of it. It doesn't go into effect until after the next election. So you can't raise your own pay while you're sitting in the seat. Now, you might get reelected, and if you do, well, then you do get the benefit of it. And we all know that most people do get reelected, right? But the intent of it was so you couldn't raise your own salary. You had to raise a salary for the person who came after you, not for yourself. When was this amendment first introduced? 1797. That is not a typo. 1797. It went out with the original Bill of Rights. It didn't pass back in 1797. 200 years later, we passed it. So when people argue, oh, the ERA is too old. I mean, it was passed in 72, came out of Congress, and we just can't have something that's, 50 years old. Well, excuse me, the last amendment you passed was 200 years old. So that kind of shoots that argument right out of the water. So that's the legal answer with, in 50 pages by lawyers for the timeline issue. On the rescission issue, other states have attempted that as well in those previous cases that I mentioned you. Even New Jersey tried to revoke their passage of the 14th Amendment. New Jersey. You don't think in northern states trying to do that, but they did. They tried to revoke their passage of the 14th Amendment, and other states tried to revoke their passage of the 14th, 15th, and 19th Amendments, none of which have ever worked. And they said, no, you don't get to do it and then say, oh, I changed political power, now I'm taking it back. No, this is a one and done. You do it, you're done. It's done. That's it. So all of those cases have gone to the Supreme Court and have, that's what they've held. You don't get to do, it's not a do-over thing. So those are the main legal arguments. Now, in addition to that, we're also still running a political strategy as well, a congressional strategy to get the Congress to get rid of the timeline. It's not, in the legal argument, it's not necessary, but it doesn't hurt to have it thrown out, right? So last Congress, they threw it out in the House. This Congress, they threw it out again in the House. It was passed in March of 2021. So now it's in the Senate, and it's SJ Res 1 in the Senate to eliminate the timeline. So there is no timeline. So the court cannot use that as an argument. Because remember, I told you, Congress has the sole ability under Article 5 to determine amendments. So if they say there's no timeline, there's no timeline. So we need the Senate to pass this, and they have not. They didn't pass it last time, they haven't passed it now. So the strategy is a Noah's Ark strategy in the Senate because they're trying to keep it bipartisan and keep as many Republicans on it as they can so that they can hit that 60 mark, right? With the filibuster in place. So the Noah's Ark strategy is all the Democrats want to sign on, every one of them. But they're trying to say, bring a Republican with you. Now, one of the things that the lovely Kirsten Sinema says all the time is what a great bipartisanship relationship she has and how she works across the aisle all the time. Why hasn't she brought a Republican with her to sign SJ Res 1? She says she's in support of it. We have it in writing. Then why doesn't she bring a Republican with her to sign, co-sponsor it? With all her great bipartisanship that she claims. We've asked her that. We get no answer. But, so that's the strategy is, we know Kelly won't do it until Sinema does it, but that's the strategy is to try to get Sinema and Kelly each to get a Republican and co-sponsor this thing to increase the numbers because they're trying to keep them equal. What happened last time was they tried that, it didn't work. We got close to the end of the session. And so then it said, okay, fine, open the doors. All the Dems came in and no more Republicans. So there were like 2 Republicans or something. So once again, this is something else the filibuster is holding up, trying to get this passed. All right, so now this is the big question is, what difference will it make? And many, many people say this. Well, what does it make, Diane? I mean, we have Title VII, we have Title IX, we have Roe v. Wade hanging by a thread. And we have the Violence Against Women Act, which has not been reauthorized yet. So that's the problem. Things do not have to be passed again. Things are hanging by a thread. Unless you have constitutional equality, it can be revoked, it can be changed, it can be modified. You don't have it anymore. Now, I want to explain these things on the bottom, and then I'll go back to the top again. The big difference it will make once you have constitutional equality is the standard of analysis by the court. There are 3 ways that a court looks at a constitutional question: strict scrutiny, intermediate scrutiny, or rational relation. The lowest level of analysis is rational relation. If there is any relationship between the bill that was passed and the issue that they claim to be addressing, it's okay. For example, years ago, they passed in Illinois a law that said women could not be bartenders unless they were married to or the daughter of the owner of the bar. Yeah, I know, it's pretty funny, right? Because I was a bartender, and when you said about at the beginning about taking last
Last call. Yeah.
last call, yeah, we used to say last call for alcohol. You don't have to go home, but you can stay here. So, but if they passed this law in Illinois that women could not be bartenders. Now, women could be waitresses in that same bar, but they couldn't be bartenders. Now, why was that? We all know bartenders made more money, right? So women sued, and the rationale of the legislature was, if they were the daughter or the wife of the owner of the bar, and a drunken man in the bar tried to take advantage of the woman, if that man knew she was the daughter or the husband, the wife of the owner, that they'd get a punch in the nose, so they wouldn't do it. Well, we know that isn't so, but that was the rationale. So their answer, of course, was, well, what about the waitresses? They're the ones that are out on the floor standing next to the table of the drunk guys. That's who's going to get, more likely to be grabbed and, assaulted and groped and all of that, than a woman standing behind that long bar where they can't get at her, right? Well, it doesn't matter. I mean, the court actually said in that case, it doesn't matter if the rationale is true. It doesn't matter if it's really the real rationale. So long as the legislature can give some reason of any kind that relates these two things, we'll let it go. So under that rationale, women never won a case. We brought many cases, and I've written a long paper about this. We brought many cases, but we didn't win. I wasn't alive then, but we didn't win. So in 1963, a new thing came about, which was called intermediate scrutiny, which was Craig versus Bourne, which was a case in which the courts elevated the analysis for women only to intermediate scrutiny. It's not as high as strict scrutiny, but it's not as low as rational relation. And under intermediate scrutiny, the reason given for the law has to have some actual relationship to the action, and there has to be some kind of proof that it really works. Not like that bullshit reason that, he's going to get a punch in the nose. So that made it harder to discriminate against women, but still women lost, at least 50% of the cases, because intermediate scrutiny is just that, intermediate. Now, what's strict scrutiny? Strict scrutiny is the highest level of scrutiny, and it's based on constitutional protection. Race, color, nationality, or national origin are all in the 14th Amendment. Thou shalt not discriminate based on. They're actually named. It's race, color, condition of previous servitude, i.e. slaves, and national origin. Those are mentioned in the Constitution, the 14th Amendment. So you cannot discriminate based on those categories. And religion, that's in the first, right? So you cannot discriminate. So if a case comes up of discrimination under one of those categories against somebody who fits into one of those categories, it's very, very tough. Because not only does the state have to show that they had to do this law, it's really for the best of everybody, there's a good reason, it works, and they have to show there's no other way they could achieve this goal but to do this particular act, which unfortunately discriminates against somebody. Well, how often does the state win that argument? Almost never. Almost never. So under the strict scrutiny analysis, we will win. That is the most important reason to have constitutional equality, because the level of analysis of the reason for the discrimination will be raised. We tried to do this through the cases. After we won this case in '63, Ruth Bader Ginsburg and the ACLU Women's Rights Project and Polly Murray and lots of other famous lawyers tried to push this forward through the law, like they did with Brown versus Board of Education. You bring one case and another case and another case and another case, and you build on it until you push it up. So we were hoping we could push women up to strict scrutiny through Supreme Court decisions, like corporations did. We failed. And in 1993, in the Virginia Tech case, Virginia Military Institute case, not Virginia Tech, Virginia Military Institute case, where they were saying, why is the state of Virginia paying for a military institute that won't allow women? Well, we won the case and they have to allow women, but who wrote the decision? Ruth Bader Ginsburg. And she said, women don't get strict scrutiny. We all shook our head. I was a lawyer by then, and we're all shaking our head going, what? Why would Ruth Bader Ginsburg say this? This was her 30 years of her work. Well, I found out the reason why was she would have lost the case. It was a 5-4 decision, and she wanted to put in strict scrutiny, and she would have lost one of the votes. It would have been a 5-4 the other way. We would have gone backwards to rational relation. So she had to, it must have broke her heart. Must have broke her heart to do that. But that was in. That was in. We couldn't get it after that. That was 1993. No more cases were brought. So let me give you 2 other examples. What time? How much time have I got?
We're running just about done here, so.
Okay, 2
Yeah.
quick cases. I'll tell you why it matters. Morrison versus Brownski. US versus Morrison, sorry. Brownski versus the university. Anyway, in the first Violence Against Women Act, there was a provision put in there that if the local people do not bring sexual assault cases for women, and they often don't, then they can bring a civil rights case in the federal court, which is what blacks can do. The small towns would not prosecute people who were beating blacks, shooting blacks, killing blacks. So they would go to the Supreme Court, or they would go to the court and file a civil rights case. So we put that same provision in for women, thrown out by the Supreme Court. Why? Because there was no hook. And they actually said this, no hook in the Constitution to tether women to. And the second case was FGM, female genital mutilation. And this was a case where they passed some laws in Minneapolis and Minnesota that you can't do female genital mutilation in Minnesota. So what did they do? They took their kids over to North Dakota and did it. So Congress passed a law saying, when it's against the law in one state, you don't get to move your daughters over to the other state and do it. They threw it out. Why did they throw it out? Because they said Congress has no tether in the Constitution to protect women. This is real. This is not bullshit lawyer talk. This is real, how it impacts women and why we have to pass the ERA. So I ask you to take the 2 actions that I had for you tonight, and that's the end of my presentation. I will stop sharing screen. And if we have any questions, I'm willing to answer them.
Wow. You're welcome to unmute yourselves and ask questions if there's some questions for Dianne. And you have the actions. Did you put the actions in the chat as well?
No, I didn't. I just put them in the PowerPoint, but you have the PowerPoint.
Yes.
I do. Yes, we do. Okay, we'll get that out to members.
Okay,
Thank you.
great.
Dianne, do we have your permission to put the PowerPoint or parts of it on our website?
Yes.
Great,
Yes.
thank you.
All right, thank you. And we also have a newsletter that Betty puts out once a month, and I can put out newsletters anytime. We can both put out, announcements anytime, so we can forward this information to all the people on our lists.
And the ERA task force, we have a website, but also our email is just ERA task force AZ@gmail.
Okay.
Anybody can contact us that way.
Okay, great, thank you.
And we have a Facebook too.
Okay.
So you see, there's a lot about the ERA that people need to know.
It's very informative. Thank you so much. Debbie?
Yeah, I was just going to say, I wrote down here at the beginning of your talk that the ERA was passed. And then we got the rest of the presentation and I realized it's not passed. So I'm going to have to listen to this a couple of times because it's so intricate.
It's very complex.
This is a legal argument.
Right.
Our lawyer group, the ERA lawyers group, we say it's passed. It's passed because it has met the requirements of Article 5 of the Constitution. And it will go into effect with the 2-year deadline on January 30th, 2022. Now, the courts don't agree with us. You know, there are many, not many, several of the amendments that have been sued about. And this is just, we knew this would be, and it is. So our argument is it's passed. But the court is not yet, Fiero has not yet published it in the Federal Register, and the courts have not yet said, oh, you win the suit. So that's where you're hearing the different contrasts. The
Okay,
enemies say it's not passed.
so we can take action by writing letters to the addresses that you gave us.
Two things right now, we want Merrick Garden to withdraw that memo and get the hell out of those cases. And we want the senators to co-sponsor SJ Res 1 to eliminate the timeline.
Okay,
So that is not a legal argument in the cases.
Great, thank you. That helped. Okay, any other questions before we adjourn for the evening? And this has been very, very informative.
I can give you a secular talk someday too, when you want it.
We'll have you back for that. I read through everything that organization's doing, and it's right where we all stand. So
yeah, and all the other topics that you mentioned in your email too, Diane.
yeah.
Like for-profit prisons.
Yes, yes.
Oh, yes.
Where did
yes,
Brad go? Oh, he left.
yeah, he's here. Brian's here.
No, I'm
Yeah.
here.
Oh,
Yeah.
you are? Okay, I
I'm-
could talk to you about for-profit prisons for a long time.
Oh, yes, yeah, so could I.
Yeah. Yeah.
We have the town of Florence. There's like 6 of them up there.
Yeah,
So yeah, it's unbelievable.
Maybe we could do a joint thing on that from a legal and a practical, or from you were a correctional officer and I've been suing them for years. So
Yeah. I worked there for many years, and they're trying to still siphon money away from the state to get more beds when we don't need
need 'em.
those beds.
Yeah. It's crazy.
They should be releasing the nonviolent drug offenses that probably 60 to 70% is drug and or substance abuse. It's amazing. You'd be totally baffled. I mean, I know you're aware of it, but it's like, it's unbelievable. And they're asking for more money. They want $16 million more
Yep.
for private contracts for CCA and Geo Group and all these private for-profit
They do.
companies. And it's not needed.
Nope.
It's not needed.
Yeah. Okay. Well, we've kind of gone over our time, so
Okay.
we'll tell everybody good night and thank you. And
Thank you,
Millie,
Mike.
yeah, Millie, if you send me your PowerPoint, I can get pieces of that in the newsletter also. Okay, thanks. Okay,
Thank
good night, everybody.
Thank you,
This
guys.
was wonderful. Thank you.
thank
It
you
was a
so
good
much.
meeting. Thank you.